but it's more when you know this person is so powerful that however you respond, and even if you do respond, you may be wondering for the rest of your career how they have processed it and decided to deal with it against you.
Hi, Professor Green. It's great to see you.
Hi, glad to be here.
Hi. So I'd like us to start by talking about the legal definition of harassment. Could you tell us what that is?
There's a landmark case, Meritor Savings Bank, where the Supreme Court talks about sexual harassment. It talks about unwelcome activity of a severe or pervasive nature that affects terms and conditions of employment.
How do courts think about unwelcomeness in the workplace versus consent?
So when we think about sexual harassment and the issue of it being unwelcome, that's a little bit different than when we think about a criminal act where you ask the question, did the person, the victim, consent to this behavior? In Meritor Savings is probably a good example. The plaintiff, female, had sexual activity with the supervisor involved dozens of times because she felt she had to do it to preserve her job status. Now, that might be consensual in some aspects, but under the Title VII definition, it's not looking at it from that perspective. It's whether it was unwelcome for her to have been exposed to that kind of situation where she felt she had to do it to keep her job.
And the court, of course, in fact, found that to be unwelcome behavior.
They did.
In your paper, you mentioned a standard of empathy that you think could be incorporated into the consent, to the idea of consent. Do you think that that's connected somehow to this unwelcome thing? Can you say more about this empathy piece?
The empathy should be looking at the vulnerable employee who has no choice really. And I talk about this a little bit. Once that executive makes this overture, the options are really limited and quite daunting for that person. Even if they are positive in their mind that they want to have a relationship with that executive, the options are just not that great wherever they go. And that's where the empathy needs to lie when something does go awry and that person does come forward and makes a complaint. That's where we should be empathetic in terms of how we analyze those things. I'm not preventing the executive from still defending himself or herself from saying that I didn't harass this person or I didn't do anything improper. I'm just taking out the one little part about consent,
Yeah.
because they didn't say no.
Yeah.
That's the only part I'm taking out.
I do feel like the reason this is a hot button issue is because the crux of these disputes in these situations is rarely like, the victim was making it up. I mean, these disputes almost always revolve around admitting to have engaged in the conduct and then having a dispute over the meaning of the conduct.
I've seen this at universities too, in terms of policies and relationships with students and faculty and other things. And there's talk about adults being adults and allowing people to make decisions as long as they're informed. Google has developed a little policy where you only get one ask.
Oh, is that right?
Oh, yeah.
That was funny.
Yeah. So you get one ask if you want to ask somebody out or whatever. You get one ask, and whatever their response is, it could be ambiguous, whatever it is, you don't get to ask again.
So, going back to #MeToo, what was like the dumbest excuse that you heard from an executive who was accused of harassment, and why do you think it was dumb?
I think what probably spurred me to write this paper is Tavis Smiley.
Okay.
And so he made comments like, what's wrong with dating people in the workplace? And where else are you going to go to find love? And Barack and Michelle met in the workplace. So what's wrong with that? and even admitted that he owns his own company and has dated several people who work for him and never at once acknowledged the potential power differentials that are involved in all of that. And then, of course, there's Les Moonves from CBS. So if you look at the paper, I start off with two comments from both of them. And where Les Moonves uses that no means no, and that he understood that, but yet there was one situation where he admitted that a physician treating him, he tried to kiss the physician.
Oh,
And it was just so shocking to me. And I guess he would have said, well, as soon as she said no, I would have stopped. But what person thinks that a doctor coming to treat them, that that's your first step is to just kiss them?
I mean, I do think there are probably people in the world who are like, that seems reasonable to me. Like, why do you find it outrageous?
What seems reasonable to me?
I mean, okay, other than the
My doctor
like
comes up
attacking the
and wants to kiss
doctor,
me.
like the others, like Tavis Smiley's thing, like, yeah, I meet people in the workplace, like that's my thing. Like, why do you find that outrageous?
The thing with Tavis Smiley is more just the complete blatant unaware position, and kind of what Jennifer was just talking to me about, like the empathy. There's a lacking of empathy whatsoever for what the position the vulnerable person is in. That's more. It was more shocking to me that he was so openly blatant about what's wrong with this.
So you're really focused on that class of relationships that's supervisor subordinate or executive subordinate.
To be at an executive level in a major corporation, you not only affect that person's terms and conditions of employment in that corporation, but maybe in their whole career and industry. And I highlight a couple of instances in the paper, some of them involving Harvey Weinstein, where the argument, even, and Les Moonves said this too, he never did anything, but when they have such power, you're not in a position to even know how they can be harming you by even just being innocuous when someone asks them what they think about you as a former employee. Anita Hill talked a lot about that when she was questioned about Clarence Thomas and why she stayed in contact with him after her allegations against him.
We have sort of helped this problem become a problem in ADR with our secret agreements and our confidentiality clauses. And now we just hear about Jeffrey Epstein getting that plea bargain that made it so that so he was able to get away with very bad behavior. And I noticed there were no ADR prescriptions in your paper. I wonder if that was, is that because you don't think there are alternative dispute resolution mechanisms that would help?
I've written about this a little bit in terms of criticisms of ADR because it is private, and that there are some types of disputes that do require a public resolution. And with the Me Too movement, some of the things that we're seeing, because of how people have been silenced for so long, it needs to be public.
What role do you think men play in, or can play, or should play in the Me Too movement?
I try to highlight, there's one section where I talk about how women can be the harassers. And you can have vulnerable boys and men who are subjected to the same concerns that I have. Um, and so I may not look at it as just what can men do, when other people do, but in general, what should we all be doing when it comes to looking at this? And I go back to the empathy, and I think the Me Too movement is certainly helping that by bringing out, as Catherine McKinnon said, where now people are listening to the stories that people come forward with instead of assuming that they're not true. And we all need to be sensitive, men and women, in terms of how we interact with each other in the workplace when there are power differentials.